Hi, everyone. Thank you for joining. We're just about to get started on our webinar, Co-Employment Risks and Direct Sourcing. Some housekeeping just to get out of the way. There is a dedicated time at the end of the webinar for Q&A. If you can see on the bottom of your Zoom screen, you'll see this Q&A box here. That's where all of the questions can be submitted. This session is also being recorded, and we will send out that recording at the end. And lastly, there will be a survey at the end as well. So please, if you have time to answer that, that will be greatly appreciated. This session will be a little interactive. So Eric will ask a few questions throughout. Anything he asks, responses can go in the chat. So that chat here is also in the bottom of your Zoom screen there. So you should be able to see that. This is our panel. I'll get into some more introductions in a second, but thank you for joining. This is our agenda for today. We just did the housekeeping, and then we'll pass it over to Eric, and he'll do understanding co-employment. He'll talk about some of the risks associated with co-employment, a few mitigation strategies, and then we'll pass it off to Ted, and he'll do a LiveHire overview, and then we will get to that live Q&A there that you see at the end. And I'm pleased to introduce our speakers today. We have Eric Rumbaugh. He is a labor and employment relations attorney. He has a nationally recognized practice in contingent labor, so he's sure to bring really great insights on this topic. And then later you will hear from Ted Bleefnick, SVP of Sales in North America. Ted comes with over 20 years of experience in the MSP, RPO, and contingent labor strategy area. So excited to hear from him later on, and pleased to pass it off over to you, Eric.
Okay, so I have been talking about co-employment because there's been questions about co-employment basically my whole 35-year of practice. And I've been working not exclusively in the contingent labor space for that whole 35 years, but largely in that space for the whole 35 years. And we never run out of questions regarding co-employment. And now with the prevalence of businesses adopting direct sourcing programs, the questions have come up over the last couple of years, especially, how does that affect co-employment? And this is a topic that I've talked about a lot over the last 5 years. So I've got a couple of good takeaways for you. But before we get started, I'll start with this proposition. We're going to go over what in a minute, we're going to go over what does it mean for somebody to be your employee, somebody else's employee, or a co-employee, and how do you determine that? So before we jump into that, I'll ask the audience, and you can use the chat feature, not the Q&A feature for this. What factors do you think courts care about in determining whether somebody is your employee, somebody else's employee, or a co-employee? What are the things that you think courts and state and federal agencies care about legally in making that determination? And if somebody wants to throw into the chat factors that they think are important, I'd like to talk about those for a minute. If nobody throws out a topic in the chat, then I will just tell you what the answers are, but I'm interested in hearing what the audience thinks ab initio.
Oh, apologies. It looks like the chat is disabled.
So that's why nobody's chatting.
That is why, but we do have a few in the Q&A, Eric, if you can see them in there.
All right, I cannot. Why don't you read them?
Okay, we have behaviors of control,
Okay.
duration,
So behaviors of control was the first one. What was the second one?
duration,
Curation. I'd be interested.
Duration.
Duration. Okay, got it. All right.
taxes,
Who withholds taxes? Okay.
a work direction,
Work direction, I'll call that control.
Mm-hmm.
Anything else?
That's it so far.
Okay. So we're going to start off with, how do you define co-employment? What factors matter and why do we care? I'll start with the why do we care. Um, we shouldn't. It's not illegal for somebody to be your co-employee. And in most cases, in a contingent labor setting, they are your co-employee, and there's nothing you can do about it. And there's nothing you need to do about it. It's not illegal to have co-employment. Co-employment isn't a risk in and of itself. Misunderstanding co-employment's a risk, but again, in most uh, co-employment in most contingent labor settings, the courts and the federal agencies just presume that you've got co-employment, and there's nothing to see here. In the words of Kevin Bacon, remain calm, all is well. But so the answer, why do we care, is in most cases we don't care unless we do, and we'll talk about a couple of cases where we would care. So I'm going to have you shift to the next slide, Solana. It's not letting me do it. Do, 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 do. So we're gonna start by going over a couple of the tests for whether someone's an employee. And I have been saying for years that I'm going to go through and count all the different tests for whether someone's an employee. Um, and there may be, I'm going to say there's certainly over 100 tests for employee status, um, and maybe over 200. On your screen right now is the main U.S. test for employee status. It's named the Darden test after the Nationwide Mutual Insurance versus Darden U.S. Supreme Court case. This is also called the common law test. So when courts use say where you apply the common law test, this is the test. The Darden test is important because it's, again, the most important, most common test used for determining whether someone's an employee of A, an employee of B, or employee of both, or of neither, if the person's an independent contractor. But it's also important because it's the test that all the other tests are based on. So if you have a Tennessee unemployment test, or a Michigan workers' comp test, or any other test, almost always those tests are rewordings or reconfigurations of the Darden test. An important thing to know about the Darden test is it's not a box checking test. Many states will have a list of 7 factors. You're an employee unless you pass all of these 7 factors. The Darden test isn't that. There's 13 factors, and courts almost never look at all 13 factors. They'll look at 3 or 4 or 5 or 8 of them and not even mention the others. Also, courts are allowed to look at factors that aren't on the list. And it's not the case that if 4 factors say you're an employee of a company and 3 say you're not, that you are, because the 3 that say you're not, in the court's mind, could outweigh the 4 that say you are, or vice versa. So a court could apply different weight to different factors. So that 2 factors could beat 7 or vice versa. So as the people who commented observed, the most important factor is control. Some courts will say there is no one most important factor, but every single time a court says there's a most important factor, it's always control. Who's managing, directing, or controlling the worker's work? If if the staffing supplier is providing the main day-to-day direction or control, that factor militates in favor of the staffing supplier being the employer. If it's the end client that's directing the day-to-day work of the worker, then that militates in favor of the end client being the employer. If it's neither, if the worker's directing her own work, that militates in favor of the worker being an independent contractor. In many cases, it's both the staffing supplier and the client uh, provide some direction or control, but usually in a contingent labor setting, it's the client providing the majority of control. And so out of the box, in most contingent labor settings, you start off with the most important factors suggesting that the client is the employer, and maybe the staffing supplier also might be providing some direction or control. Some of you may have heard me teach classes where we go through this, and I might spend an hour on the Darden test. I'm going to try and do it in a couple minutes, so I'm going to really run through these quick. Skill required, higher skill, think doctor, lawyer, accountant, architect, engineer, less likely that you're anybody's employee. You can have an employed architect or an independent contractor architect, but the higher the level of skill, the less likely you're anybody's employee. Who supplies the equipment? In a minute, we're going to go over the wage and hour test, the economic realities test. In that test, it takes this factor three and looks at how much did you spend? How much did the company A spend on the tools that worker uses versus company B versus the worker herself? But in all tests, does the person use equipment to do the job and who paid for it is going to be a factor worded one way or another. Number four, who controls the work site? If you're controlling the work site, this factor militates in favor of you being the employer. It doesn't mean you're the employer. The example I always use here is an HVAC contractor. If somebody, I'm in the BMO tower. If somebody shows up to fix the HVAC system on the roof of this building, they're going to fix it here, and they're almost certainly going to be not BMO's employee. They're going to be an independent contractor or somebody else's employee, even though they're doing the work on site. But factor four suggests that whoever controls the work site, that factor militates in favor of them being the employer. Somebody brought up duration as being a factor, and it is a factor. The longer you're engaged with someone, the more likely you're their employee. Although I've been practicing law for 35 years, I've had clients that I've been working with the whole 35 years, and I'm not their employee. But factor five would militate in favor of me being their employee because I've been their lawyer for 35 years. Whether the hiring party has the right to assign additional projects to hired party. Here, are you paying for the person's time or are you paying for a job? If I show up to work for Solana and she tells me to move the thing and I move the thing, when I'm done, she says, move the other thing, and I move the other thing. And then she gives me another task when that's done. If that's the type of engagement that we have, then factor six militates in favor of me being Solana's employee. If I'm engaged to perform a task and when the task's done, my engagement's done, that militates in favor of me not being Solana's employee. Factor seven, when and how long to work. Most tests conflate factors one and seven. They're both elements of control. But if you're setting the person's hours, factor seven suggests you're the employer. There's exceptions to this, like the example I always use is an ER physician. Solana and TED could be partners in a medical practice and they have their own office building and they have privileges at 6 hospitals. But when they're at St. Mary's, they're in the ER and St. Mary's tells them you've got midnight to 8 a.m. Well, factor seven would suggest that St. Mary's is their employer. Other factors would say they're not, so they're not employees of St. Mary's, but factor seven would suggest that St. Mary's is their employer because they're setting their hours. Factor eight, method of payment. If you pay by the hour, that suggests that you're the employer. If you're paying by the job, it suggests you're not. There's exceptions to this though. Lawyers typically bill by the hour and they're typically not employees of their clients. Whether the person you're hiring is allowed to hire and pay assistants. If they are, that suggests they're not your employee. If they're not, that suggests that they are. Whether the work is a regular part of the hiring party. We never used to talk about this. This is a factor the courts never talk. You almost never talk about factor 10. It's a big deal now because this is California B in the California ABC test. So people talk a lot about different wordings of factor 10 in the Darden test in the last 5 years because it's a slightly reworded version of California's B of its B test. The California ABC test, which we'll talk about briefly in a second, is a box checking test. You have to pass all three or you have to be somebody's employee. You can't be an independent contractor if you don't pass all three. And factor 10 is one of the things you have to pass. If I'm an accounting firm and I hire Ted to do accounting, Ted's got to be somebody's employee. He can't be an independent contractor under the ABC test because he's doing work that's a regular part of my business. If I'm a plumbing company and I hire Ted to help my accountant do accounting, he would pass the B test because I don't sell accounting services. Does that make sense? Factor 11, whether the hiring party is in business. If Solana hires me to cut her lawn, factor 11, and she's a homeowner, factor 11 militates in favor of me not being her employee. If she hires me to cut a lawn and she's a landscape contractor, now factor 11 militates in favor of me being her employee. Factor 12, are you getting employee benefits? Think health insurance, 401k, vacation, sick leave, etc. That whoever's providing, are you getting those benefits and who's providing them? Fun fact, in a contingent labor setting, this is the first factor that typically militates in favor of the staffing supplier or payroll provider being the employer. All the other factors point towards client being employer. So here, where someone gets benefits, it's almost always the staffing supplier. And then factor 13, tax treatment. Are you reporting payments on a K-1, a 1099, or a W-2? If you're reporting them on a W-2, that militates in favor of the person being your employee. If you're reporting them on a 1099 or someone else is reporting them, it militates in favor of you not being their employee. Fun fact, you can't take an employee and make them an independent contractor by reporting payments on a K-1 or a 1099. It's a factor, but it's certainly not dispositive. This is another of the key tests. And again, I said there might be 100 tests. This is the main federal wage and hour test. It's not materially different than the Darden test. It's just reworked. The economic realities test focuses on whether the person's economically dependent on you. If you're their only source of income, the economic realities test is going to say that you're the employer. So, but it's a rewording of some of the Darden tests. And then this is the California ABC test. As far as A, direction or control, nothing new here. C, the person's got a business. B, they're doing work outside of our normal course of business. B is the problem in the California ABC test. A and C we can deal with. When California adopted the ABC test, they turned thousands, maybe hundreds of thousands of safely engaged independent contractors into employees because of the B part of the test. So risks associated with co-employment. Really, co-employment, qua co-employment isn't a risk. You're allowed to have co-employment. And again, in most contingent labor settings, co-employment is presumed by federal and state agencies, and it's not a problem. It's not illegal to have someone be your employee or co-employee. And in most cases, there's nothing you can do about it. If you go back to the tests, applying those tests to most co-employment situations, your contingent workers are your co-employees, and there's nothing you can do about it. And again, nothing you need to do about it. But if you misunderstand co-employment, you can have lots of risks. So, for instance, it's illegal to discriminate against someone whether they're your employee or not. Race discrimination is illegal for employees and non-employees. Sexual harassment is illegal for employees and non-employees. You can get sued for it either way. So good risk mitigation tip is don't discriminate against people, whether they're your employees or not. And if you've got a staffing supplier or a payroll provider or someone you're working with, cooperate with them, exchange information with them, and jointly work to mitigate risks. Don't ignore risks because you believe it's somebody else's problem. It's both of your problem in almost all cases anyway. And problems almost always show up because someone didn't think it was their problem. They thought it was somebody else's problem. So now it becomes a problem, whereas it didn't need to be a problem at all.
Eric, where do you see the greatest or most examples for companies or employees that have opened up risk? And where do you see the greatest cases for risk?
I would say where co-employment becomes an issue, the thing that buyers are worried about is my staffing supplier breaks a law. I didn't have any control over it. They didn't pay people when they're supposed to pay them. That's something that staffing supplier controls. If you're a buyer and your staffing supplier breaks a law, you could be jointly liable for that as a co-employer, and you don't want that. The best solution to that is have you want an indemnification agreement. Staffing supplier should be indemnifying you for things that are in their control. But more important, I'd rather not have a claim than have a good indemnification clause. More important than that is have a good partner that you have confidence in that they're going to comply with the law, so that you're not in the soup for something that somebody else did that you didn't have control over. The next thing, Ted, that people worry about is benefits. I don't want these contingent workers to be eligible for my benefits. There's a simple solution to that. define the contingent workers out of your benefits. Define them out. If you look back at the famous Microsoft Vizcaíno case, the problem in the Microsoft Vizcaíno case is Microsoft didn't define the contingent workers out. The court in the Microsoft case used the Darden test that I just showed you. They didn't have to use that. Microsoft could have used a different test. They could have defined workers differently. And the Internal Revenue Code specifically permits you to define leased employees, which is not identical to contingent workers, but it's close. It's an Internal Revenue Code term, leased employee. If you use the term leased employee, it's going to capture most contingent workers. The Internal Revenue Code specifically permits you to exclude leased employees from your benefit plan. So the front door way to solve unanticipated benefits liability is to draft your plan so that people you classify as independent contractors are not eligible for benefits, and people that you engage through a staffing supplier aren't eligible for benefits. And you're specifically permitted to do that. There's another thing that you're allowed to do in your benefit plans, Ted, which is ERISA, the Federal Employee Benefits Law, specifically permits plans to give the plan administrator what's called an arbitrary and capricious standard of review. So that if you mess up and some contingent worker should have been covered under your benefit plan and you didn't define them out properly, the court isn't reviewing whether the worker was eligible or not. They're reviewing whether your plan administrator was arbitrary and capricious in denying benefits or not, which is a much higher standard. So those two things, define your contingent workers out and give your plan administrator an arbitrary and capricious standard of review. We at our firm, we call that Microsoft inoculation language. And if Microsoft's on this call, thank you, Microsoft. But it's not that we're the only ones who do this. Every law firm does it. We just made up that term. But we look at your benefit plan to make sure that you properly excluded the people that you want to exclude, which would be your contingent workers, and that you've given yourself the safety net of an arbitrary and capricious standard of review. So that's the second place where people get into trouble. One is somebody else broke a law and I might be on the hook for it. Solution for that is work closely with your staffing supplier. Make sure you've got a good staffing supplier that's responsible and is going to comply with the law as much as they can. Everyone will get sued periodically, but you want a good partner that's responsible and compliant and have a good indemnification clause. Issue number two is benefits. Issue number three, which is kind of the rub point for this, if you're a staffing supplier, is I'm the buyer, I break the law, and now I'm liable for a legal issue for somebody who's my contingent worker. So the example I always use is Solana places me to work for you, Ted. So I'm a contingent worker, I'm working in your shop. I'm a light industrial worker. I'm a warehouse picker. I'm a temp accountant. I'm a temp clerical. Whatever it is I'm doing, somebody in your shop sexually harasses me. And I sue you and Solana's company for sexual harassment. And you say, wait, this isn't fair. He's Solana's employee, he's not my employee. And now you've got a co-employment problem. The answer is, in most cases, I'm your employee and Solana's employee. And the reason why you've got a lawsuit is you didn't know that. If you knew that I was your co-employee in a harassment situation, you're not liable for the harassment, even if it happened in almost all cases, if you have a harassment policy and you follow it. So if there's a harassment policy and I complain, you investigate, take prompt corrective action and that's reasonably calculated to prevent recurrences, then neither you nor Solana are liable for the harassment. If you say, not our problem, and don't deal with it, Solana, you deal with it, she really can't deal with it without your cooperation because she can't interview your employees. So she can't investigate and take corrective action. Now you took something where nobody should have had liability, and now you have liability, not because you had co-employment, but because you didn't understand co-employment. And there's 100 examples like that. So I would say the thing that's fixable is making sure you have a good staffing partner and making sure you understand co-employment. If somebody in your shop's discriminating against someone, deal with it, fix it. Don't say not our problem, because again, race discrimination is illegal even for non-employees. even if you win the lottery and a court says, no, Eric wasn't your co-employee, Ted, woohoo. Well, that still doesn't mean you're allowed to discriminate against me based on my race. So don't be reasonable, be fair, whether the person's your employee or co-employee, then it doesn't matter. So those are kind of the three buckets I would put the classification risk in. Does that make sense, Ted?
Yeah, you said something interesting, and I think probably myself and probably a lot of us, we all started in staffing and then we went on to do other. I think back in the day, it was always, the employer would say, well, we're going to bring in a staffing agency and they're responsible for basically everything. That was kind of where a lot of temp agencies were used. So, and then in your example there, you said you want a close relationship with the agency, right? To understand, liabilities and who's responsible. So that I think has probably changed over the years where it used to be the company would say, well, that's on the agency, they're their employee.
So
So would you
let's,
say is that kind of a myth over the
it
years?
was,
Like,
it was always a myth, but I'd say that people are getting better at managing it. So I'll give you another example. Um, let's say that I'm capable of getting pregnant. I'm not. But Solana places me with you, and I say, I'm pregnant, I need leave. And you say, Eric's pregnant, get rid of him, I need another. So Solana's response to you has to be, no, I can't remove Eric. That's illegal. You're ordering me to break the law. Or it would be the same thing as if I show up and I'm white or I'm black, and you say, wait, Eric's white or he's black or whatever, get rid of him. I need somebody of a different race. That's an illegal request. Solana has to say no. It's the same thing if I say I need leave because I'm pregnant or my wife's pregnant or my kid's got cancer. If you order me removed for that reason, that's illegal. And Solana has to say no. But what if you say to Solana, we don't like Eric, get rid of him? And she doesn't know why you got rid of me. Legally, we're co-employers. You and Solana are co-employers. She's not liable for that discrimination if she doesn't participate in it or acquiesce in it. So if you make a decision and say, get rid of Eric, the real reason is because I'm pregnant or I have cancer and need leave, or my wife's pregnant or my kids, I need time to take care of my kid to the hospital or whatever. So, or because I'm white or because I'm black, she doesn't know that your request was illegal. She just knows you requested it and she followed it. You're liable. She's not. Many buyers believed historically that's their problem. That's why I hired you, Solana. And if the answer to why I hired you is so I can discriminate against people and not have to worry about it, that's not why you hired Solana. And Solana should fire you as a client. So if you hired her so you could just break the law and have it be her problem, that's not a good reason. But I would say if that was your experience 20 years ago, that was common. Businesses would hire staffing companies. They would never say, I hired you so I can break the law and have it be your problem, clean up aisle 3. But that happened. I would say very few buyers believe that now. They shouldn't have believed it 20 years ago. They've been disabused of that now. The solution is we can get rid of Eric, but Ted and Solana should have lawyer-to-lawyer conversations and come up with a lawful way to get rid of Eric. So we're not breaking the law. We're not getting rid of Eric because he's pregnant or because he's got cancer or whatever. We've got a lawful reason to get rid of him. We're not skipping the due diligence piece. We're treating it the same way as we would if Eric was our direct hire, and we're following the law. We're not just taking glib risks because it's somebody else's problem because we misunderstood co-employment. And again, the problem isn't co-employment. The problem is Ted misunderstood co-employment. Does that make sense?
Yeah, and even in that example, we went through extensive training. This is, years ago, but in that example where an employer says, "Hey, we want to fire Eric," and they don't give a reason, wouldn't a good partner, a good staffing partner to help mitigate the risk say, "Well, let's talk about why you want to fire him," right? Just to ensure that you're on the same terms and there's viable reason to fire him. Wouldn't that be a
In a
good partner
great
move?
relationship, the two would partner on risk management. Although Solana might know her counterpart at TED and just trust that you are following the law. Now, another thing that comes up, Ted, is buyers will say, I'm not firing Eric. I'm just removing him from assignment. You can fire him or not. You can place him somewhere else. That's an adverse
Mm-hmm.
action. Telling Solana take Eric off the account is an adverse action. It's the law is going to treat it the same as firing me. So this belief that we didn't fire Eric, we just told you to remove him. If I sue, you're not going to get anywhere saying we didn't decide to fire you. Solana's allowed to place you somewhere else. We just said we don't want you here anymore.
Mm-hmm.
The we don't want you here anymore piece is going to be an adverse action, is going to get you as a defendant in a lawsuit. You might win, you might lose, but you'll be a defendant. So the risk management piece is don't skip risk management because somebody's not your employee. They might be your co-employee, but even if they're not your co-employee, most forms of discrimination are illegal anyway, whether they're your employee or not. So don't skip risk management thinking it's somebody else's problem. You can, when I'm representing the supplier, we can take a lot of weight off of our buyer's shoulders. Oh, you got a problem with Eric? Let us take care of it. We can move Eric out safely, efficiently, and with little or no risk if you tell us you need Eric moved out. If you just do it yourself without involving us as partners, it might or might not work out. But having a staffing supplier or payroll provider that works as a partner with you is critical. And I would also say, if you're going to do something that's taking a legal risk, don't have email trails back and forth between Ted and Solana on these issues. Have your lawyer call their lawyer and talk through it on the side. Don't create a paper trail of discoverable evidence of the fact that you really don't want me here because I'm pregnant.
Mm-hmm. Yeah. We do have a question, Eric. You want to take a stab at it here? Outside of IC, are there any co-employment differences between various labor categories, statement of work, or general staff aug or hourly employees?
So that's a great question. If anyone's heard me talk on this before, I think statement of work is one of the most abused concepts in the world. So for application of employment law and eligibility for benefits, the issue is, are you an employee or not? Taking somebody who might be an employee, might be an independent contractor, and saying, no, they're a statement of work worker is a glib way to pile up liability like cordwood. You still have to make the call. If you're going to engage me on a statement of work, you still have to make the call, am I an employee or not? If I'm an employee, I'm going to get benefits from somebody. If I'm an employee, somebody better be withholding my taxes. If I'm an employee in California, somebody better be making sure that I have a paycheck that complies with California payroll rules and that I get my paycheck every week and I get my final paycheck on my last day. And I better be getting covered by workers' comp premiums. So using the word statement of work and saying we don't have to address the question of whether Eric's our employee, their employee, or nobody's employee is again a way to pile up liability like cordwood. Using the term statement of work doesn't obviate the am I an employee and whose employee question. Does that make sense, Ted?
Mm-hmm. Yeah.
So the answer is the answer to your question is there's a lot of classifications that people use, but there's still a binary am I an employee or not issue. And I would also submit that under the Internal Revenue Code, there is no such thing as co-employment. For tax purposes, the employer is the person who manages or directs or controls the work, or if it's not them, it's somebody else who's agreed by contract to withhold taxes. So in a IRS context, the client's the employer. The only reason the staffing supplier is the employer is because they have agreed by contract to withhold taxes. Otherwise, it would be the client because they're the ones who are managing, directing, or controlling the work. So the client's the employer. And again, there is no co-employment for tax purposes. There's one throat to choke for the IRS. There's one entity that has to withhold taxes. It's almost always the staffing supplier or payroll provider in a contingent labor situation. But again, in most cases, they're the employer because and only because they agreed by contract to be the employer. Otherwise, it would be someone else. Does that make sense?
Definitely. So there's another question that kind of in the same vein, I think would be good. If you make the decision to have an assignment end and the supplier immediately finds them a new assignment with a different client, are we still liable for adverse action, although their employer still has them working?
So if the worker thinks that the new engagement is disadvantageous in any way, under, I would say historically, the answer would be yes, you have at least potential liability. You might not get sued, but you have potential liability. There's a recent case within the last actually couple of months that eased the burden of proving adverse action, or at least of alleging adverse action. So I think you should assume that's an adverse action, even if the worker's damages are mitigated immediately. If the worker makes the same amount of money right out of the box and their only remedy is back pay, then you'd have liability but no damages. But that's an adverse, if you should assume that that's an adverse action unless it's clearly better. So here's the big takeaway. I will hear my client buyers say, we're not firing, we're just removing them. That's an adverse action. Don't think you don't have legal liability because somebody else is actually paying them. You're doing something that they think is adverse. It'll be up to a court to decide if it meets the standard of being an adverse action. And I will tell you that very recently that line moved south. The burden became easier for workers to plead adverse action in a way that we don't like, the people on this call. But you should assume that's an adverse action. And it'll almost never be zero wage loss. I've never seen it be zero wage loss where the worker never misses an hour. But if the worker never misses an hour, you'd have at least potential liability, but no damages. Unless there's emotional distress damages.
Another one that we've come up with many a times was inaccurate hours recording. So if a contract worker has fabricated their hours and then the employer is signed off on them, like that can be a massive wage dispute. I guess how does that work? Who's liable in that situation? How do they work together to avoid?
So in most cases, it's going to be the staffing supplier that'll have liability for unpaid wages. And in most cases, everybody will be able to lawfully rely on the hours that the worker reports. So if I write down that I worked 28 hours and Solana pays me for 28 hours and she's placed me with you, Ted, neither you nor Solana are going to have liability if Solana paid me for all the hours that I recorded. The reality is in these cases, whether there's co-employment or not, even if it's just I'm Solana's direct employee and there is no co-employment, you didn't pay me for the hours I worked, the worker will have some syllogism for why their hours that they reported aren't accurate. You told me I wasn't allowed to report hours over 40 in a week. You knew I was working over 40 in a week, but you ordered me not to report them. That's probably the most common iteration of how this comes up. Or I had a case once where our client's a hospital, and the particular, it was an ER. And in that state, there are rules regarding numerosity of staff. We had to have a certain number of doctors, a certain number of nurses in the ER, different times a day. We didn't pay the nurses for break time. And the nurses said, you knew we didn't take breaks. And in fact, had we taken breaks, you would have gone out of compliance the second we went on break with the number of staff you had to have in the ER. That case ended up settling, but we had a lawsuit over, yeah, those are the hours we recorded, and you know for a fact they're not accurate. Because if we did actually take a break, you wouldn't have been in compliance with state law regarding staffing levels. So every time, the short answer is you can rely on what the worker recorded as their hours, except when you can't. If you tell a worker not to record all their hours, or there's some reason why you know the worker's working extra hours, then you have at least potential liability. Are there records that the worker worked longer than they reported? And should you have known about those? That's where that litigation ends up defaulting. and the worker's story either makes sense or it doesn't. You start off in the driver's seat if you pay hours reported, but every time we have this litigation, the worker's got some explanation for why the hours they reported aren't accurate, and you knew about it.
Kind of in the same breath, you mentioned providing work direction, right, on assignment, but what about performance reviews, write-ups, even firing? How do they work together to avoid a risk in that whole sector after the work is being given?
So performance reviews, write-ups, and delivery of news. You're fired, you're promoted, you got a raise, you got a pay cut, you got new benefits, you lost benefits, whatever. So who's delivering the news to the person? Really, I'm not saying that's a bad idea. I'd say that's standard in the staffing industry is that type of message is almost always delivered by the staffing company. But if I'm in your build, Solana places me with you, Ted, and I'm in your building, and Monday through Friday, one of your staff is telling me what to do. If the message of you're doing a great job, you're getting a 25 cent an hour raise, or you're doing a bad job, you're suspended, or you're doing a bad job, you're fired. If somebody in Solana staff gives me that message, the cow is already out of the barn in terms of management direction or control by virtue of you giving me my management direction or control 9 to 5 Monday through Friday. You're not undoing the management direction or control piece by having her be the one to tell me I'm fired if I was getting my management direction or control from you all week. So I'm not south on the idea of having your staffing supplier deliver all the messaging. I'm fine with that. That's normal. The industry's used to that. But don't think that having your staffing supplier be the one to deliver the message somehow takes someone who's in your building using your equipment under your direction or control all week and makes them not your co-employee. That's a misunderstanding of co-employment. You're not moving the needle on co-employment with that in most cases. Does that make sense?
Yeah, very. When it comes to that too, if a contract worker were to, maybe it goes both ways, either email or talk to the staffing supplier or the client, say, hey, I'm having an issue. So let's say they email or call their staffing company. They say, hey, I'm having an issue with my manager or someone else on site, and the staffing agency doesn't take action. How can they avoid risk in that scenario where
So the key here is take action, make sure somebody's taking action. If a worker has a problem with a manager, that's a red flag. And we want to make sure everybody knows we're escalating it and who we're escalating it to. Classically, that would go to the staffing supplier. The staffing supplier would interview the worker and say, okay, what's your problem with the worker? If I got that report as the client, I would refer that to the staffing supplier. I would tell the worker, hey, you should report this to Joe. Or I would pick up my phone and call Joe and say, hey, we got a report from one of your people. They've got a problem with one of our managers. Could you take care of it? Now, in many and maybe even most or almost all cases, Solana's Joe, the person who's investigating this, is going to have to get information from us. Joe's not going to be able to go in and interview our manager and get his or her side of the story as to what the problem is, but somebody's going to need to do that. So you and Solana, Ted, are going to need to cooperate on that investigation. You don't want to have the situation be where you say, Ted, nope, there's not going to be an investigation. If this person doesn't like it here, get rid of them. Because if the thing that the person's complaining about has some legal issue, now you're taking a problem that didn't need to be a problem. Nobody needed to get sued here. And now you're saying, nope, we're not dealing with it. It's your problem. Get rid of this person. Get rid of Eric if you want, but you're not interviewing our person and we're not interviewing our person. That's just bad management by you. Solve the problem. We want to be a go-to place of choice for talent to come. We don't want to be jerks to people. Not being jerks to people would probably be our best risk mitigation technique, but cooperate with your supplier. And if I'm a supplier, and half the time I'm representing a supplier, I want to be the problem solver. I'm the risk mitigator. I'll take all this friction, and in almost all cases, I'll make it go away. So you can run your railroad, Ted, and you don't have to worry about these people. But you have to give me more than no cooperation. You have to give me something north of no cooperation if I'm the supplier. And if I'm the buyer, I want my people to cooperate and use my staffing supplier as a partner, to lean on them, have them do stuff for us, have them carry out the task that they should be carrying out, but not just put my head in the sand and say, not my problem. You're your people, you deal with them, and we're not going to cooperate with you at all. That's a way to take something that didn't need to be a problem and make it a big, fat, hairy problem.
Yeah. And there's so much truth to that. I know tongue in cheek is, don't be a jerk, but there's so much truth to it. And you've said a couple of times, don't bury your head in the sand, don't turn a blind eye, but there's a lot of truth to just addressing it, treat them like humans, and that will foster the right type of action, the right type of behaviors when it comes to, mitigating risk from co-employment. There's some good questions. I want to save them to the end, though, if that's all right with everyone. But maybe touch on kind of direct sourcing, benefits of direct sourcing, your experience with direct sourcing for, the co-employment topic.
So let's say Solana is placing people with you, Ted, and you've tasked her with going out and recruiting to get you the best people. They could be architects, they could be accountants, they could be engineers, they could be nurses, they could be whatever. They could be lawyers. If Solana is exceptionally talented and has access to really, really attractive people, she could be recruiting lawyers. So whatever she's recruiting for, she wants to get the best people. The benefit of direct sourcing is you recruiting or Solana recruiting on your behalf is leveraging your brand. People see working for Ted as being a destination. Either you on your own or Solana working for you can get more and better people at better rates if we're leveraging your brand and letting people know that they're going to be working for you. And this is true whether you're doing the recruiting yourself and you're going to be having Solana payroll the people, or you're having Solana do contract recruiting for you on your behalf. I will hear companies say, I'm worried about using our brand. I'm worried about leveraging our brand because I'm worried that it's going to create co-employment risk. And the answer is no, it's not. It's not if the worker's working for Ted, they're in your building doing work under your direction and control. They know that they're working for you. When the fact that they knew they're going to be ultimately working for you when they were getting recruited doesn't move the needle under any of the tests for employment status. Are they your employee or co-employee? That's going to depend on, are they in your building, using your equipment, doing work for your business under your direction or control? If the answer is yes, they're your co-employee. If the answer is no, they're not. And whether they knew on the way in that they're going to be doing work for you as opposed to doing work for Solana or whoever's payrolling them doesn't matter under the tests. Now, I will hear people say, but I don't want Eric thinking he's Ted's employee. That's not part of the test. My zeitgeist, my impression, my sentiment about who I think my employer isn't part of any of the tests. You might say, for morale purposes, it's better off for us to other Eric and remind him repeatedly that he's not our employee, he's Solana's. That doesn't move the needle under the test. You might think you're getting some psychic HR benefit out of reminding me that I'm other. I would say upon reflection, most of my clients, when they think about this, realize that othering exercises like giving me there's 100 things that businesses could do to remind me that I'm other. I'm not saying they're bad ideas, but they're not going to move the needle on co-employment. And I'd say in most cases, you don't need to remind me I'm other. I know it very well that I'm not getting the same paycheck as the person next to me. They get paid more than me. They get better benefits, and they get to park in the Dumbo lot instead of the Goofy lot. I'm well aware of it. But some companies think that they get a psychic benefit out of reminding me again and again that I'm other. I think I paraphrase Joni Mitchell here. Something's lost, but something's gained by those exercises. In my judgment, typically more is lost than gained, but it's in the eye of the beholder. I'm not against those othering things, but they're not moving the needle on co-employment. Does that make sense?
Yeah, absolutely. Well, why don't we Solana, you want to move on to the next page, and if you have the deck.
I do. Co-branding.
I
Yeah,
think we
perfect.
covered that, Ted.
Covered
Okay,
it. Yeah.
great. Yep.
So risk mitigation. So if you're worried about co-employment risk, number one, periodically look at your benefit plans. I would suspect that everyone on this call has modern, appropriately drafted benefit plan language that incorporates what we at our firm call Microsoft inoculation language, but periodically have it reviewed. One thing that you need to know, and you don't need to know more than this for purposes of this meeting, is even though the Internal Revenue Code permits you to exclude leased employees, it usually makes you count them for purposes of what's called discrimination testing. And discrimination testing in this context has nothing to do with race or sex discrimination. It's highly compensated versus non-highly compensated workers. You're allowed to exclude non-highly compensated workers, but if you exclude too high a percentage of them, you can threaten the tax qualified status of your plan. So if you're a benefits attorney or a benefits accountant, that's your global thermonuclear disaster, losing plan qualified status. So they are very mindful of this ratio of non-highly compensated to highly compensated workers eligible and participating. So you don't need to know more about discrimination testing other than your company does it and they get a report card once a year. And although I told you you're allowed to exclude leased employees, there's a limit to how far that can go, and that limit is caused by discrimination testing. Your benefits people could tell you more about that. Just you need to be aware of that as an issue. Review your plans periodically to make sure you've got modern language and you're not leaving out people from the exclusion list, or they're not properly excluded in your definition that you mean to exclude. Here's my next biggest thing that people forget about: insurance. If you've got a staffing supplier or a payroll provider, you're requiring them to maintain certain types of insurance and to list you as an additional insured. Who looked at that last? Where did those numbers come from? What type of coverages are you requiring with what policy limits? Do the standard policies have exclusions that are a problem for you? For instance, with cybersecurity, there is no standardized policy. You have to actually look at the policy to see if there's an exclusion that's a problem. This is my biggest bugaboo for my buyer clients. You've got paragraph 11 in our staffing contract that says, here's the insurance that you should be carrying with the policy limits and the types of coverage. Where did that come from? Somebody created paragraph 11. They almost certainly didn't create it for the engagement that we're doing. And I don't know how long ago it was that somebody looked at it. I have been doing this for 35 years. I'm not qualified to tell you or anyone else how much insurance you should be requiring for vendors in a particular situation, what policy limits you should have, and what policy exclusions are a problem and might need a rider to overcome. That's an underwriter problem. That's an underwriter question. You need to meet with your insurance broker periodically, tell them what you're doing, tell them what other people who might be independent contractors, statement of work workers, contingent workers, consultants are doing on your behalf and or in your building, and periodically ask them, are these insurances that we're requiring appropriate? Are we leaving out coverage we need? Do we have extraneous coverage that we don't need? Are the policy limits right? Or do we need some type of stop loss or secondary insurance? Periodically have that discussion for yourself and for your partners. Second, make sure that you've got insurance that's secondary that covers the same thing as your staffing suppliers. You want theirs to pay first. Make sure theirs is adequate and make sure yours is adequate. You don't want to find out we had a claim, we're not covered because we have an exclusion for our claim for people doing work under our coverage, and this person was actually your employee and we didn't know it. Make sure your coverage is in place and it's adequate, whether the person is your employee, somebody else's employee, or nobody's employee. Don't wait for a worker classification determination to find out if you've got coverage. So long-winded, look at your insurance coverage with your broker and with your lawyer periodically, if you haven't done it recently, and most businesses don't do it often enough, do it with your Eric, whoever you've got that does what I do, in the room at least once. You don't need to have the lawyer in the room every year. Once you go through the process once, it'll be easier in year 2 and a lot easier in year 3. But periodically look at your insurance. Overall risk management, don't ignore risks because you think somebody else isn't an employee or somebody else's employee. If I'm in your building and I trip and fall and break my leg, that's a bigger risk for you if I'm not your employee than if I am your employee. So manage risk appropriately. Don't not manage risk because you think somebody's not your employee. You've got risk whether they're your employee or not. You might offshore the risk to your staffing supplier or your payroll provider, and that's going to be appropriate in a lot of cases, but don't ignore it. Make sure somebody's handling it. In dispute resolution and escalation, you want a partner that knows how to escalate, that works with you to escalate to get the problem solved before you get to court. If you've got a good staffing partner, you can work with them to kill most problems before they become problems. And I like you involving counsel early. I don't like text trails between my frontline supervisor and your frontline supervisor. They're going to get used against me in court. Once somebody spots a problem, if it's the staffing supplier hears about a problem, I want them escalating it to the lawyer, and I want their lawyer calling me, calling my lawyer. I don't want a bunch of discoverable text traffic at the ground level that I can't talk my way out of later. And then the biggest risk mitigation piece is have a good partnership with your suppliers. Get suppliers that aren't dummies. They'll just do whatever you tell them. You want suppliers that are going to be actually value adding and are going to be working with you as stewards of your brand and stewards of your resources to help mitigate and reduce risk at every step. And a good partner will be doing that. And a good partner will see that as their job.
Awesome. Thanks, Eric. I think why don't we, Solana, if we jump into a question or two, there's some really good ones in there, and see if we can close this out in the next 3 to 4 minutes. I'm not sure if we can enable the question feature on this or not, but I'll go ahead and ask here for I won't say any names yet, but according to legal policy team, if the line manager were to give negative feedback directly to the contractor instead of the staffing firm, would this constitute co-employment risk? Is that accurate?
And my answer is, was the worker already your co-employee? And I mean, my answer is in most cases, if they're getting management direction or control from you all week, the fact that your line supervisor gave direct feedback is an indicia of co-employment, but you already had co-employment. Them giving feedback would only be important if the worker was on the bubble as to being your employee or co-employee ab initio. If the worker was already a co-employee, the answer is it doesn't make any difference. And in most cases, they're already your co-employee and it doesn't make any difference. Now, important caveat. I am not saying that you should routinely have your frontline supervisors be giving feedback directly to contingent workers. It's a standard industry practice for you to have your frontline supervisor pass along the feedback to the staffing supplier and have the staffing supplier give the feedback. But in most cases, you're not moving the needle on co-employment, not because you giving the feedback is irrelevant, but because you already had co-employment. You can't take someone you're managing all week and then have somebody else tell them they did a good job or a bad job and say, aha, they're not our co-employee because we had somebody else deliver the feedback message. A court will laugh at that. It doesn't matter. The thing is, who's doing the blocking and tackling Monday through Friday? If it's you, you're going to be at least an employer. Somebody else might be a co-employer, but you're going to be an employer. And you're not going to change that by having somebody else deliver the messages.
Great. We are bumping up on time here, but clearly, look, if you want to talk co-employment, Eric is your man. Tons of experience, lots of passion for this space. We want to thank Eric for speaking with LiveHire. Certainly, on behalf of LiveHire, thanks everyone for attending. Obviously, Eric spoke highly. We're going to have him on more calls to sell on behalf of LiveHire and the importance of direct sourcing. But last thing we'll say is that the time is now, right? With this pullback in the contingent workforce, spend and volumes. Now is a great time to engage Eric on employment law and LiveHire, your MSP partners, for standing up a strong direct sourcing solution and building those talent communities. But I just want to thank Solana, thank Eric, and thank everyone for attending today on behalf of LiveHire. Thank you all very much. Reach out if you have any questions, and we'll be sharing the decks afterwards. Thanks all. Have a
Thanks
great
all.
day.